The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talkboard TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, Tampa. Welcome to another Ask the Expert show where we bring you, without a doubt, the top experts in the field of legal, health, financial, and home improvement. My son the other day asked me, he said, "Dad, you do all these shows. You've been doing it for 12 years. What is your favorite show?" And, I got one or two. I don't just have one, but I have one or two. And without a doubt, the K. Bender Rimbaum law firm, community association firm, is without a doubt one of my favorite shows to do. We've got them in our Tampa market, our Orlando, and our South Florida market. I actually still, after 12 years, look so forward to doing this show. Let me welcome you. Standing in today, our long time now expert in community association law, attorney Alan Swartzide. Hello, attorney.
Hey, Steve. Thank you, sir. You were very diplomatic there in how you expressed which shows are your favorites. I appreciate that. That was a very lawyerly comment to make. Well done.
Hey, listen, I'm trained by the best, Alan, you know what? We're so lucky. We've got you today, and we've got you on Thursday in our Orlando, your market, Orlando. I got to tell you, it's so easy doing your show. And I came in one time when Robert was doing, the Ask the Lawyer.
Yeah.
That I thought was going to be for about an hour. Ended up being 2 hours. And I got to tell you, people came in. Some didn't even have a question when they walked in the door, but most of them end up asking 3 or 4 or 5 questions. And that's what this show is about. Here you have an attorney that you can ask a question by condo or HOA associations. There's so much going on. We're so glad to have you. Let's get started. Tell people about K. Bender Rimbaum.
So we're full service community association only law firm. We only really represent condos, HOAs, and co-ops in the state of Florida. We practice statewide. You mentioned we operate in Tampa. We've got an office in Tampa. Kirsten Henza runs that office and usually helps you with this show. I manage the Orlando office, so I'm still local. I practice throughout the state as well. We've got offices in Pompano, which is our main office, in Palm Beach, and then Miami by appointment. This is what we do day in, day out. The attorneys that work with our firm, there are 20 of us, and all we do is work with community associations, except one guy who he's the bad apple of the bunch. Great guy, but still the bad apple. He only does construction litigation for community associations. He's like super specialized. But, we've got 8 attorneys who are board certified in community association law, one that's board certified in construction law. And the bottom line is anything that comes up in a community association, you mentioned my partner, Robert K. There's nothing that's going to come up that guy hasn't seen in this industry. There's very little I haven't seen. But you talk to Robert, and it's like, the guy Ben Stein that does the Win Ben Money Show. Well, Robert's him, but with a personality. He knows everything about everything about this industry.
Well,
So I
it's so
think it's a
good.
fantastic firm. That's why I'm here. But I'm not here to sell services. I appreciate the opportunity to pitch for 30 seconds. That was my elevator pitch. But I'm happy to answer the actual question, Steve. Thank you.
Well, if you'd like to, there's a lot of different ways you can ask Alan a question. You can call in at 561 623 9429. 561 623 9429. If you're watching us, that phone number goes across the scroll. We also have a chat line that a lot of people use, or you can send us in a text, which we always get about 25 to 30 texts each month. We love your texts, and we get as many of them on as we can. So I guess let's get started. We have got so many questions today, and it just I want to put one thing in, Alan, about your firm.
Sure.
Basically, all you do is community association law.
Correct.
I got to tell you, most firms who do this have a line of areas that they represent. They might have family law, criminal law, personal injury. You are one of the few firms that this is all you do.
Yeah, I agree. And I think that's important. I mean, you'll get into, and we get into this every month, about how specialized and how specific this area of law can be. I mean, I've met a bunch of real estate attorneys who were board certified in real estate, board certified in litigation, but couldn't read a declaration to save their lives. And that's the bottom line. These are the things we do every single day, and it's all we do. And the more niche down you get, I mean, anyone that reads books about who does the best work, who learns, how do you learn the best? And it's that 10,000 hours that most of us within the firm have way more than 10,000 hours into this practice area. But if you don't specialize and you've got 1,000 hours, you're definitely not going to get that expertise, and you're probably going to miss something that people like us would know. Oh, the statute says this, but it's not in the document, so you might miss it. I think it's crucial for every community to use an attorney that specializes in this area of law, whether they have board certification or this is their main focus of their career and their practice. But again, I'm not going to go off on that let's push the firm tangent, but I appreciate the opportunity to explain why that is, in my perspective, extremely crucial that you use an attorney that knows this area of law.
Well, let's get to our chat line first. We're going to go to Dino. He said, I'm seeing multiple deeds come in where the notary is one of the two witnesses and then notarized all. Doesn't that defeat the purpose? Doesn't it defeat the inherent of a self-authorizing deed in Florida?
So it's actually a separate portion of the Florida statute. It's the real property. Right. I appreciate that clarification. It's a real property transfers law. It's not a condo or an HOA law that talks about that. But I understand the concern because a lot of condo amendments and certificates of amendment, things like that, require the same specificity, the same form as a deed. So you're still having that notarization and two subscribing witnesses, etc. This is something that's expressly authorized in Florida statutes and has been for some time. So I understand why it would make sense to need another witness, but especially in a time where half the people that are notarizing things are doing it via their computers, via remote online notarization, I don't see that being a necessity to verify that this is. Keep in mind, let me step back. The purpose of notarizing a document is to ensure that the person that signed it is the person they say they are. You're basically verifying that this particular individual signed it on this particular date. I don't know that having a separate witness would make that any more clear that it was this person, because the witnesses are just watching the person sign. It's the notary that's actually verifying via a driver's license or because they personally know this person that the person signing is who they say they are. So I just don't see it being a major issue, although I can understand the concern, but this is something that's been allowed under Florida law for a while now.
We got a text this morning because they knew you were going to be on, and he begged me to ask you this, and I don't even really know if you can answer his problem. He lives in a condo, a very large condo association, and
Okay.
he said they do not have assigned parking. People from across the way will park in their parking lots because they have more than one car, and he can never find a parking space. Who does he go to?
He has to go to the board first, and the board needs to adopt a resolution authorizing towing within the community. Then they have to find a towing company that's actually going to do the towing. I mean, technically, if you look at it from a legal perspective, the association has the ability and the authority to find someone who doesn't even live there and is just using their facilities in violation of the governing documents. But the likelihood that you're going to get an injunction that's actually going to be successful in stopping these people from parking there, from my perspective, rather than spend a whole bunch of money in attorney's fees and costs. I know I'm one of the few attorneys that'll actually say don't spend attorney's fees. But the bottom line is, rather than spend months and months trying to get this resolved and hope that you can figure out whose car it even is in the first place, rather than spend that money, spend that time before you finally get an injunction against this person, I'd rather see you spend that time and money putting a towing policy into effect, having a resolution of the board that says that the board is authorized to tow vehicles from the community if they're not authorized to park in the locations where they're parked, putting signage up, which, by the way, should be addressed by the towing company themselves and shouldn't cost the association anything, and then having the towing company just come in and remove those vehicles. And you'll have signage up that warns these people, if you're not authorized to park here and we find your car parked here anyway, it's going to be towed. I mean, to me, that's the straightforward solution and the least costly for the association.
Alan, what do you tell a client? What do you tell a client about assigned spaces? It would seem like that would eliminate some of that problem.
That might eliminate it, but that doesn't necessarily mean that it's going to completely eliminate it. You'd be surprised at the amount of times where we've got those assigned spaces, but someone across the way from another community doesn't know whose space it is. Are you going to spray paint the person's name or the unit number on the space itself? Are you going to put signage up next to every space saying whose it is? I don't see that resolving this particular problem is the issue. If it's people within the community that are parking in someone's assigned space, then yes, absolutely, that helps. But I didn't mention that specifically because the question was about people that don't even live in the community that are still parking there. But yes, very good point. Assigning parking spots might be an option. It really just depends what the declaration provides for and whether you think you can adopt an amendment if that becomes necessary to have those assigned parking spots. Chances are it's something the association can do.
Speaking of parking, we've gotten a few text messages. People are upset because they're having signs that are being put up, no back-in parking.
Yeah, and that's largely to protect the association in being able to determine the license plate number of the vehicle. We're in Florida.
Okay.
We're not in one of those states that has license plates on both sides, or in those countries that have the license plates on both sides. So the only way of knowing the license plate number of that vehicle is to not allow backing in. So I questioned that at first myself, frankly, before I was even an attorney. And I said, this makes no sense. Why would you not allow me to park the way I want to park? But that's from my perspective, at least, that's the rationale. We want to know, is this person authorized to park here or not? And in the instance that we talked about just a minute ago, you would have no idea unless you had, decals or something of that nature towards the front of the car or something hanging down from the rearview mirror. You would have no idea whether that's a car that belongs in the community or someone that happened to be driving by and saw an open parking spot. Think about in Tampa, in certain areas of South Florida, near the beaches, and even in Central Florida, in Brevard County and some of the surrounding areas, Ormond Beach. You have people that'll take whatever spots they can find so that they can walk to the beach.
Right.
Okay.
Exactly.
I don't want backing in that type of instance. I want to know, and even in Central Florida and in Tampa, where you've got, a stadium that people are walking to, it's the same situation. I want to know who I should be towing and who I should be allowing to park in this space. That's really the rationale.
Okay, let's go to Super Florida Dude. For a condo, what is the meaning of incomplete and insufficient accounting records? A management company is presenting reports to the board with large mid-six-figure errors.
Well, that's not really a defined term in the Florida statutes, but it sounds like anything that's mid six figures would be a problem. It's not necessarily relevant what that definition would be. It's whether or not this is a sufficient error to justify the association requiring them to make up for the error. And whether you should or not is going to depend on the circumstances. But yes, my perspective is if a management firm makes a multiple six-figure error or a mid six-figure error, that's something that they should be figuring out how to fix it for you. Insufficient accounting is generally you weren't complying with your legal obligations in your financial reporting, in your accounting as to where the funds are going, things of that nature. But there's no real statutory definition. It's really, were you complying with your obligations or not? If the answer is you were not, then most management firms will make up for that, or they'll offer something to make it work and fix the problem. Now, I also don't know, based on the question, was this an error in the budget and the association doesn't have enough money and can levy a special assessment to make up for that error? Or is this money that should have been there and is missing, which is a bigger issue? Either of those is a big issue. But really, how that management firm should be responding and reacting will depend on the specific circumstances of each individual dispute. And hopefully this is something that they're willing to fix for you if they cause the error.
Okay. Stephen Brandon wants to know, I am a new association resident. This is all new to me. Can you tell me the difference in partial and fully funded reserves?
So a fully funded reserve means that, let me take a step back and explain what a reserve even is, because that might be helpful. A reserve is basically money you're setting aside so that when one asset of the association is expected to fail, you'll have the money to replace it or repair it. So for example, your roof is one thing that every condo in Florida needs to reserve, your roofs, plural. Let's say it's a $100,000 roof. Okay, that's what it's going to cost to fix it. Good for you. It's relatively inexpensive. I use that as a clear, even number. If the association is going to fully fund that reserve and you've got 10 years when that roof is expected to fail, then what you're saving every year is that $10,000, so that by the time that's expected to fail and you're going to need a new roof or you're going to need major repairs, that $100,000 is sitting in a bank account ready to be used. Partially funding reserves means we don't want to charge our members that entire 10 grand. And by the way, I'm way oversimplifying this, but if partial funding would be, we don't want to charge our members that 10 grand because that gets spread among, we're talking about multiple reserve assets, meaning we're adding, let's say, 5 grand to the budget 20 different times. And now all of a sudden we need $100,000 from our members. If there's 100 members, that's another $1,000 a year that goes into the budget. So instead of doing that, some communities will underfund the reserve or partially fund the reserve. That's putting 5 grand into the budget, knowing that at some point you might not have the money to cover what you need. Now, again, this is a vast oversimplification on a straight line method of reserves. It's not accurate, but it's as close as I can get without spending 45 minutes answering the question. So that's partial funding is basically, we know we need that 10 grand every year to have what we need. We're going to fund less than that each year. Partial funding just means it's not funding the exact amount that you'll need to cover that reserve asset when you need it. And you can make up for that later. Go ahead, Steve. I'm sorry.
Well, we're going to go to our first break, Alan. I'm telling you, this show goes by so fast. Let's give everybody the phone number and also give them the website address. And we come back, We're going to talk about your schedule for next month.
All right. Sounds good. So our offices can all be reached by calling 954-928-0680, regardless of which office you're trying to reach. The website is www.kbrlegal. That's where you can find, kbrlegal.com. That might help. And that's where you can find literally everything we do except for your actual legal work. So Steve, I'll leave it to you.
We're going to go to break. When we come back, we're going to go over your schedule for next month. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. We're with you every week at this time. If you'd like to call in now, we do have a line open at 561-623-9429. This is our K. Bender Rembaum Community Association law firm. We have attorney Alan Swartzide with us today. And let's go over your April schedule, Alan.
Sure. So we actually still have March 27th, another class coming up at Capriccio's. That's in Broward County. Might not help the people on this meeting. Another one, a condo board certification via Zoom that I believe I'm teaching. I'm not sure. So that's going to be, and then March 28th, we have funding construction projects. That's via Zoom as well. We also have the Tampa Condo and HOA Expo coming up. We've got a ton of classes coming up in April, including, I think, 3 or 4 that I'm teaching. But the easiest way to get access to all of this is to just go ahead and check out our website at kbrlegal.com and click on the calendar. You can register directly from the website for any of these classes or any of the events that you want to attend, including getting links to pop on to this radio show today and on Thursday when I'll be back for the Orlando market. So we've got a lot coming up, and unfortunately, I was provided a list that is not as extensive as it usually is. Frankly, that's probably a benefit to everyone, because if you're interested in any of these classes, just go ahead and go over to the website instead of listening to me.
Well, I got to tell you, we were talking about before the show, we are being inundated by email, people wanting to know, they're hearing about all these new laws that might be coming up. They've passed a legislator. They have not been signed by the governor. So until then, we're going to kind of hold off on that. But we just got a text from one of our listeners. Did the Florida law change regarding yearly certification for board members? I don't know if that passed yet.
That's one of the ones that's pending. I believe it did pass, but again, like you mentioned, Steve, none of this, to my knowledge, has been signed by the governor yet. He's got a certain amount of days, I think it's 10 days, from when the legislature approves it to either sign it or it's deemed approved or vetoed. It's going to be up to the governor. So that's why, as we discussed, my suggestion is we kind of table those discussions on what the law is going to be until next month, at which point the governor will have signed it, vetoed it, or it'll be, pending. And keep in mind, none of these laws would go into effect, to my knowledge, based on what I've read, until at least July. That's usually the way it works. Some of them might be October. All the ones that I've read that pertain to community associations would be kicking in July if they're signed. So none of this is going to be in effect until we actually get the opportunity to explain it all to everyone, preferably next month. Once we know what's the law, what's not, we can certainly discuss what was passed, what wasn't, but frankly, I think it's more productive to hold off and only discuss what's coming up, even if you want to have just a whole session where all we do is talk about the laws that changed.
Well, one of the things that I've heard that would be wonderful is regarding education, furthering education. I think you can never have too much education. This is what K Bender does. This is what the firm does.
What we do. Well, and
yes.
You want an example? I literally taught a collection class today on Zoom from 2 to 3:15. So we do find education to be very important. That is one of the changes that I hope will be made. It was approved by the legislature, and it's basically that rather than being able to sign a piece of paper that says, I read the governing documents and I kind of understood one or two words in the entire 100 pages worth, you would have to actually take a board certification class as a new director. I don't recall offhand whether that was going to be renewable every year, which I believe is the question that was just up on screen. But I do know that rather than being able to just sign the document, you'd have to actually do both.
Oh,
so we'll see how that plays out.
Let's go to Joanne.
All right.
Does an HOA board need to take a board vote before seeking a legal opinion on multiple issues? Can a president and VP keep the attorney opinions from the other directors?
So that's two questions. That means you're going to pay double for it. The bottom line is that you don't have to have a board decision to seek a legal opinion, but you do need to have the board's authorization. I've come across situations where we were asked for legal opinions that only one person wanted on the board, and then the rest of the board gets upset that the association is being charged for the attorney's fees. So my suggestion is designate one or two people that are authorized to reach out to that attorney and make sure that the attorney knows this is who I'm authorized to talk to. This is who's authorized to ask me questions. And hopefully, anytime they ask me that question, they've at least texted or emailed the other directors. Now, whether that opinion that has been given can be kept from other directors that's been given to two of them, frankly, the only time that would be appropriate is if the opinion is about actions that those other directors are taking and there is potential litigation against those directors that might be filed. But as a general, hey, we got a legal opinion, we want the president and the secretary to be the only people that are allowed to have it. No, it doesn't work that way. The opinion goes to the association, not the individual directors. And as a result, it's the board that gets to decide whether to keep that attorney-client privilege, not the individual directors who get to decide that. They get to decide it as a board, as a group.
Okay, let's go to our phones. Good afternoon, caller. We've got Finkelstein.
Yes. My question is, when the declaration provides that we can have 3 to 7 board members. We currently have 5 board members and have had 5 for many years. We're interested in possibly taking on 2 more board members.
Okay.
Can the board just make a motion to agree to hire to take on 2 more board members themselves? Do we need any other permission to do that?
No, I mean, if the And I'm presuming it's the bylaws rather than the declaration, but if your governing documents say that it can be anywhere between, usually it's 3 and 7 or 3 and 9, it would be usually a written resolution authorizing the increase in the number of directors, followed by the board appointing those individuals until the next election comes up.
Okay, that's what I thought. Appreciate it. Thank you,
All
Alan.
right, good job.
Thank you, caller. I got to tell you, everybody is still asking about the new laws. Just, you know what? I'll bet you, Alan, by your next show next month, I think we might have, from what I understand, the governor might sign some of those new laws. But as of right now, you're right. Let's just hold off on it.
And my understanding, just to be clear for all the people that are asking about this, my understanding is that by next month, we'll have to have those answers. Because if it went to the governor, I believe the governor's only got 10 days to veto it, or it's considered, and it's adopted basically. So my guess is by next month, we will have to have the answers as to what's been adopted, what hasn't, et cetera. And I would be surprised if we are not in the process as a law firm of setting up some kind of webinar explaining all those things as to what changed, what the new laws are going to be. And if we haven't set it up by next month, it'll be a legal update that we submit for approval with the DBPR so that we can start teaching that class formally through the firm and on Zoom.
Okay, we're going to go to Jack in Clearwater.
All right.
This has got to be a cousin of yours, Alan. This is the best show on the internet. Our board listens to your show every month. Are condos supposed to provide cable?
So that first part, you're absolutely right. This is the best show. Are condos supposed to provide cable? Not necessarily. There are bulk contracts that the association can enter into, and they can benefit both the association and its members. Some of them, I hate to be blunt, but will end up with the association being paid in exchange for the use of the facilities of the condo. Some of these vendors will actually, it's not a kickback, it's not a problem, it's not being paid directly to the directors. It's actually a payment to the association in exchange for what's called an easement, being allowed to use the roof, being allowed to use certain rooms and other areas of the condominium to put the equipment that's needed to serve the entire community. It's something that does generally benefit the association and the members, but it's certainly not something that the association must provide unless for some reason your governing documents say that you must provide it. At that point, it does become an obligation of the association. And if you choose that you don't want to provide it anymore, that would just require an amendment to the governing documents.
Well, I've got a great question for you that I know a lot of people would love to know the answer to this. There's a very big community that several of their members actually called us, and they're putting in a new golf course, which they say the one they have was absolutely sufficient. They're putting in new restaurants, and they want to know, why are they spending all this money with the way the economy is now?
One word: competition. You're competing with other communities to keep your property values, and especially in a golf community. When you're in a country club or a golf community, you're competing with every neighboring community, every other community, especially, when you're talking about these types of communities in particular. Sometimes it's not that you're competing with everyone in Tampa, you're competing with everyone in Florida. And so if you're not keeping up with the times in your restaurant, it's adequate for the members, but it may not draw people in that are coming to look at potentially buying into your community. That's a reason. I mean, my parents live in a golf community in South Florida, and they just redid the entire golf course, one of the 3. And my parents are not thrilled with the additional expense, but they know that their property values are going to go up because it's going to make the community more desirable. The same thing applies to a restaurant.
So it's going to help property values.
Correct. It's going to help the
That
marketability
makes
of
sense.
properties. It's going to help property values. And frankly, you might get better food. I can't promise that. It depends on the chef. But the bottom line is that it's competition. That's really the reason that people would do it, even though what they have is already adequate.
Oh, that makes a lot of sense then. Okay. Oh, this is from Barry. Can CSRS reserves be pooled?
So that's a good question that I don't know that anyone has the answer to right now. The statute is about as clear as mud as to whether those particular structural integrity reserve studies reserves. And when we say those specific reserves, it's the ones that are mandatory, meaning the association by a date certain has to be including those reserves in its budget. Whether they can be pooled, the DBPR is about as clear as mud. The statute's about as clear as mud. And frankly, even if DBPR says that they can be pooled, I don't necessarily take that as gospel, because once you pool them, I don't know how you take them out of the pool, because you can't do anything with those funds. You can't change them. So the funds would just stay there. The bottom line, Barry, is I don't know, because I don't think that the legislature has cleared that up. And I don't believe that it's going to be entirely cleared up, even if the Condo 3.0 that's currently being proposed is actually adopted by the governor. So the answer, and I rarely give the typical lawyer answer, is it depends.
Okay. Let's go to Jason in St. Petersburg. Is my HOA or condominium association responsible for repairing damage to my home?
Probably not, but you'll have to look at the declaration and the Florida statutes. I mean, it depends what caused the damage. You know, I'm dealing with a situation right now where our response was no association. The tree that fell was not your responsibility because you had no reason to believe it would fall. But if the association knew that it was a dead tree and didn't cut it down and it fell on someone's house, then yeah, they might be responsible. So it really depends on the specific circumstances of your situation. Generally speaking, damage to your house, unless the association actively caused it, is not going to be the association's responsibility. A condo unit is generally the same thing. There are even more stringent requirements in a condo because of the insurance laws that apply to condominiums in particular as to who's responsible for what. So the answer that I can give you is probably not, but it's feasible depending on the facts and circumstances of your individual case.
We have a viewer who wants to know, they bought a condo and their real estate agent didn't tell them all the fees. What can they do?
Sell. I hate to be blunt, but it's technically the owner's responsibility to know all this information, even though I fully acknowledge most homeowners have no knowledge of how to even get that information.
Right.
I frankly, this is my area of law that I practice on a daily basis. And more than a decade ago, so not recently, but I bought a condo unit and had no idea of probably $1,000 worth of monthly invoices that I was going to receive from the country club community that my parents now live in instead of me. I ended up selling it. And that's why I kind of flippantly, I'll acknowledge, but I say, if you can't afford it, you got to get out, because the association has no legal obligation to just not charge those fees. The bottom line is, if the association's charging you something, there's a 99% certainty in my mind that it's directly associated with expenses that association is going to be spending, either maintaining the property or managing the property or operating the association itself. So the bottom line is, I wish I had a better answer for you, but the only thing you can do is find that information out in advance by not relying on your realtor to get you accurate information. And I understand that it's entirely reasonable to most people that this is the person that's going to give you the information. Where else would you get it? That estoppel certificate that you probably got a copy of or saw a copy of as part of the closing, that's the only other place that you'd get it.
Okay, let's go to Kathy in Riverview. Are restaurants in our condo association required to be open every day?
Nope. That's an easy answer. It's up to, and here's the thing. You say it's in your condo association. It depends whether it's operated by the association or if it's operated by a separate corporation, a separate entity, a separate club, whatever it may be. The association may have a contract with the person that owns and operates it, or just the person that operates it. There's no hard and fast rule other than you're going to have to look at the contracts and the governing documents to make that determination.
Let's go to Carter in Tampa. Our board realized we don't have enough money for a previous loan. Do we pass a special assessment? Can we pull it from our reserves?
So whether you can pull it from your reserves, the answer is you need a member vote to do that. If you can even do it. There are certain reserves now that you can't even pull the money out if you wanted to. We talked about those SERS reserves. They're probably untouchable. When it comes to the special assessment, the first thing you want to look at is whether you have the authority to levy a special assessment for something like this. If the answer is no, then you have two potential options. One is you amend your actual budget in order to include for the rest of the year all of the assessments that should have been included to pay off this loan. The other is you basically treat this, if you can't do that for some reason, you treat this as kind of an emergency, because defaulting on a loan, I don't know what the consequence would be, but the collateral is sometimes a special assessment in and of itself, or hopefully you didn't screw up and do this wrong and make your common areas, common elements, the collateral for this loan that would be foreclosed. Hopefully you had some guidance in getting this loan in place. And by the way, any contract that involves a community association should be one that's reviewed or drafted by your attorney for that reason in part.
Yes.
But whether you can get that special assessment in place, you might have an argument that it is an emergency, that you would have defaulted on the loan if you didn't pass the special assessment. So you can, I won't say ignore, but to some extent avoid the consequence of having a provision of the declaration that requires a member vote. The bottom line, the easiest way to do this is to have that special assessment, have the required vote to pass that special assessment if it's something that's authorized in your governing documents, and just get the funding in. But that might qualify as an emergency to the extent that otherwise you'd be defaulting on a loan. It's just going to depend what the collateral for the loan was.
We're going to go to our last break. The name of the law firm is K. Bender Rimbaum, and we're going to go to break. Give everybody the phone number, Ellen. It's good to all the locations around Florida, as well as your website address.
All right. So that's 954-928-0680. I can be reached easily at AS, my initials, at kbrlegal.com. The website is www.kbrlegal.com. And the other place that might be helpful, because I do post something at least once a day during the week. I took last week off because I was on vacation, but I'm back today, is on LinkedIn. Just look for my name that's up on your screen now.
Great. We're going to go to break. We come back we have more with K. Bender Rimbaum.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-978-5277 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we're back for our final, around 5-6 minutes. We're here with Attorney Alan Swartzide, K. Bender Rimbaum. They're with us every month. We have a show that we do here in Tampa. We have one in Orlando, and we have one in South Florida. I got to tell everybody, we so appreciate you taking the time to write your questions in, to call in, to go on our chat box. It is very special to us. Alan, you do such a wonderful job on the show. And I've got about 4 or 5 more questions. I think we can get at least a couple more in. This is from Greg in Tampa. He wants to know, are there any records of association that should not be accessible to unit owners?
There's a whole list of what shouldn't be accessible to the unit owners, and it's right in the statute. It's basically attorney-client privilege materials, personal information, medical information. There's just an entire list. So, if you need that list, I can get you the statute. Just shoot me an email as to which type of community you're in, a condo or an HOA. I'm happy to provide that. But the short answer is yes, there's an entire statutory list of things that are not subject to inspection or copying by the members.
Okay. Reed in Tampa, can a condominium association restrict the sale or rental of a condo unit?
Only if your governing documents allow it, and specifically the declaration. So if your declaration doesn't contain those rental or sales restrictions, the answer is you've got no power to do that.
Okay. I think that's going to take us right up to the end, Alan.
All right.
It's so wonderful having you on. And this is going to be special. Now I'm sucking up. Now it's going to be special because I've got you back on Thursday again.
Yeah, just 2 days. I'm looking forward to it.
Alan, give everybody your phone number one more time.
954-928-0680.
I'm going to try to get this question. This is from Jim. Where can I find the rules about, commingling funds at investment level in the financial reporting level?
So that's generally going to be in the Florida statutes, and if you're in a condo, the Florida Administrative Code. Okay. That's the short answer.
Well, I got to tell you, the phones are still ringing. They're still sending letters in on the chat. We'll just have to wait for next month. Alan, thank you so much. We love
Thank you for having me. I appreciate it. And thank you, everyone that watched, listened, et cetera. And especially, as Steve mentioned, that asked those questions that, frankly, give us free content. So we appreciate it.
Absolutely. Thanks, Alan. That's Attorney Alan Swartzide. K. Bender Rimbaum. We'll be back with you again next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.